The Supreme Court heard two cases today on male athletes competing in women's sports. Justices heard argument in these landmark cases that could alter the future of women's sports in the U.S.
Do you think sex in Title IX can reasonably be interpreted to allow different states to take different understandings of that in their sports leagues?
I do, because I don't...
Why is that? That's real important, I think, going forward.
Right. Because I don't think the purpose of Title IX is to have an accurate definition of sex. I think the purpose is to make sure that sex isn't being used to discriminate.
Two cases were on the docket today. The first was Little versus Hecox. Idaho bans males from participating in female sports. Lindsay Hecox, a biological male, wanted to join Boise State University's cross-country team. Hecox later filed a lawsuit saying the ban violated constitutional rights and the Equal Protection Clause. The main question: can states in alignment with the Equal Protection Clause require athletes to compete based on biological sex? The other case was West Virginia versus BPJ. West Virginia has a Save Women's Sports Act in place that requires public school and college sports teams to be designated based on biological sex. BPJ is a biological male who wanted to join a school's cross-country team. PBJ's mother filed a lawsuit saying her child's exclusion violates Title IX and the Equal Protection Clause. The question here: can states designate girls' and boys' sports teams based on biological sex using Title IX and the Equal Protection Clause? Joining me now to discuss this further is Mary Rice Hasson, the Kate O'Byrne Senior Fellow at the Ethics and Public Policy Center. Thank you so much for coming on.
Thanks so much.
So there's a lot going on. In today's landmark argument, U.S. Supreme Court Justice Samuel Alito pressed the attorney for the plaintiff, questioning how Idaho state law defines boy, girl, man, and woman as part of determining whether discrimination occurred. Let's take a listen.
We do not have a definition for the court, and we don't take issue with we're not disputing the definition here. What we're saying is that the way it applies in practice is to exclude birth sex males categorically from women's teams, and that there's a subset of those birth sex males where it doesn't make sense to do so according to the state's own interest.
Well, how can a court determine whether there's discrimination on the basis of sex without knowing what sex means for equal protection purposes?
How significant is this and the repercussions it could have for America?
Well, these cases are tremendously important, but I'll tell you, Justice Alito honed right in on the core issue. What does sex mean? And is it permissible for the law to take note of differences between males and females, and, for example, in sports, to permit female-only sports? And I think we can see that the way the arguments went, I think it's going to come down in the right way. I think we can be fairly confident that the court is not going to say that it is a violation of equal protection for laws to say that female-only sports must be restricted to females, that males cannot participate. I think they're going to say the same with Title IX, that Title IX does permit schools to have female-only sports. And those are important decisions. Hopefully it'll come down that way, but I think that's the way the arguments seem to be leaning.
In addition to the Alito exchange, what other points do you think will have the biggest impact on this case?
So I think one of the things that is important to notice is that the use of language is really deceptive. So the people who were suing on behalf of these athletes, these male athletes who identified as, quote, transgender, they used female pronouns. They referred to them as trans women, trans girls, as if they were some sort of a subset of females. And yet at other points in the argument, they said, no, these are a subset of males who no longer have that performance advantage because they have taken either blocked puberty in the West Virginia case, or they have taken estrogen in the Idaho case. So there's a lot of internal contradictions, but I think we need to pay attention to language, because even among the Supreme Court justices, we saw an unfortunate use of terms like trans girls or trans women as if to give validity to the point that someone can be born male and yet actually be some kind of a girl. And that's just not true. That's just not true. Sex is immutable.
Now, so many people are watching this. A lot of lawmakers are weighing in. Senator Steve Daines from Montana is a dad to 2 daughters and the grandfather of 3 girls. He tells EWTN News that he wants to protect women's sports. Here's what he had to say.
I think it's going to be a good day for America. I liked what I heard in the oral arguments from the Supreme Court justices, and thank God we've got a center-right Supreme Court, and we pray and hope they'll make the right decision here in this very important case.
Ultimately, do you think the justices will be able to make a ruling without defining sex?
Well, I think what they're going to say is for Title IX purposes, sex permits female-only sports. I think because the language of Title IX permits that kind of a distinction to be drawn. I think they're also going to say under equal protection, we're not going to grant transgender status, some sort of a protected status, as if it's a category of its own, but rather they're going to try to analyze this. Now, whether they come up with and side with the real definition of sex as being biological, I don't know. We'll see how that writes out. But I will say one of the best moments really in the argument was, I believe it was Justice Kavanaugh, who was really pushing back on the idea that this only affects just a few athletes. These are the number of males who identify as females and who are trying to participate in female sports. It's only a few, and shouldn't we make some sort of exception? And he was really very articulate in picking up on the arguments that have pointed out that for every male who joins a team, another woman or girl is being excluded. For every male who gets on the podium, a woman is not on that podium. So there's a lot of losses that may not be counted in terms of championships and other aspects. So it was neat. You could see his own experience, I think, in coaching his daughters coming through and just bringing some reality to that. But ultimately, I hope and am fairly confident that the Supreme Court is going to do the right thing and not accord transgender status, a protected status under equal protection, but rather say that it is permissible under Title IX and under our constitutional law to make these distinctions on the basis of sex.
In this case and the previous West Virginia versus BPJ, there was much discussion on classification and equal opportunity. How does a subclassification for biological males identifying as women fall under equal protection?
Well, the claim is that the distinction made by the laws saying that males cannot be in female sports, that the justification for those laws is that the males have a competitive advantage because there's a physical difference and therefore the law would be justified. But what they're trying to do is carve out an exception that says, no, if these males have suppressed their testosterone, taken estrogen, et cetera, they no longer fit within that justification, that reason why we would say it's okay to distinguish between males and females in terms of sports. And the court really wasn't buying that because the standard is you look at the law and you say, is there an important governmental interest? It's not a question of whether you can come up with one exception of an individual whose personal situation doesn't quite fall under the justification for the law. So that was sort of a red herring. It was an attempt to get the result they want while skirting the actual constitutional law there.
Mary Rice Hasson, thank you so much.
You're welcome. Great to be here.